Taiwan elections, political repression masquerading as the rule of law. Officials in the U.S. executive and congressional branches regularly praise the development of democracy in Taiwan and the conduct of elections. Is this praise justified? Let's look at the facts.
Election fundamentals. Here is a one-paragraph introduction to elections in Taiwan as posted on the website of the Central Election Commission.
Elections in Taiwan have been conducted by the Central Election Commission, CEC, under the authority of the Republic of China Constitution since its promulgation in 1947. The municipality, county, and city elections commissions are also under CEC's jurisdiction. All elections are processed on the basis of the presidential and vice presidential election and recall law, and Civil Servants Election and Recall Act, and under the principles of fairness, universal, direct, and free suffrage, and secret balloting.
Now, let's look at the provisions of the Presidential and Vice Presidential Election and Recall Act. Chapter 1. General Principles. Article 1. This act is enacted pursuant to Article 46 of the Republic of China Constitution and Article 2, Paragraph 1 of the Supplement to the Constitution. Election and recall of the President and Vice President shall be governed by the provisions of this Act. For any affairs beyond those prescribed in this Act, the other related laws and regulations shall apply.
From this information, we can clearly see that the elections in Taiwan are held under the authority of the Republic of China Constitution. It therefore stands to reason that Taiwan must be a part of the Republic of China. This seems puzzling. Many U.S. executive branch officials have given comments that seem to contradict such an interpretation for Taiwan's legal status.
Secretary Powell's statement.
Our policy is clear. There is only one China. Taiwan is not independent. It does not enjoy sovereignty as a nation, and that remains our policy, our firm policy.
Legal status of Taiwan Memorandum.
Technical sovereignty over Formosa and the Pescadores has never been settled. That is because the Japanese peace treaty merely involves a renunciation by Japan of its right and title to these islands. But the future title is not determined by the Japanese peace treaty, nor is it determined by the peace treaty which was concluded between the Republic of China and Japan.
Director Wilder's statement.
Taiwan, or the Republic of China, is not at this point a state in the international community. The position of the United States government is that the ROC, Republic of China, is an issue undecided, and it has been left undecided, as you know, for many, many years.
Chinese propaganda and Taiwan history. So when did Taiwan become a part of the Republic of China? After World War II, the announcement of the incorporation of Taiwan into China's national territory was made by the Chiang Kai-shek regime on October 25, 1945, and supposedly based on previous proclamations of the Allies. The ROC military officials named this day Taiwan Repression Day. An order effecting mass naturalization of native Taiwanese persons as ROC citizens was made on January 12, 1946, and the Republic of China Constitution was promulgated on December 25, 1947.
These announcements, orders, promulgations, etc. all form a part of Chinese propaganda, which has been expounded for over 70 years, which claims that Taiwan belongs to China. We may call it the Retrocession Day version of Taiwan's history.
The Allies and Taiwan history. But what was the view of the Allies? None of the Allies recognized any transfer of Taiwan's territorial sovereignty to China at any time in the 1930s, 1940s, 1950s, 1960s, or any other time. In their view, the October 25, 1945 surrender ceremonies in Taipei only marked the beginning of the military occupation. How did they arrive at such conclusions? Of course, they were aware of the framework of international law in the post-Napoleonic era, including the Hague Conventions, Geneva Conventions, and other established precedents which we can classify under the broad general heading of the customary laws of warfare. We may call this the military occupation version of Taiwan history.
Importantly, we must remember that it was the United States military forces that conducted the military attacks against Taiwan in the World War II period and liberated the island. The ROC played no role in these military efforts. As a result, and at the most basic level, it can be strongly argued that after the surrender of Japanese troops, it is the United States that has the first-tier jurisdictional authority over Taiwan. So, as presented above, there are two versions of Taiwan history which are commonly discussed. Which version is correct? We can confirm our answer by looking at the post-war treaties. The San Francisco Peace Treaty came into force on April 28, 1952. The Sino-Japanese Peace Treaty came into force on August 5, 1952. Did either or both of these treaties award the territorial sovereignty of Taiwan to China? The answer is no.
Such an interpretation is confirmed by a 1959 U.S. court case. The judge's decision did not recognize Taiwan as being part of the Republic of China. The case was Sheng v. Rogers, D.C. Circuit, October 6, 1959. The judges examined the legal status of Taiwan in depth and held
that the government of the Republic of China exercises authority over the island, that the sovereignty of Formosa has not been transferred to China, and that Formosa is not a part of China as a country, at least not as yet, and not until and unless appropriate treaties are hereafter entered into. Formosa may be said to be a territory or an area occupied and administered by the government of the Republic of China, but is not officially recognized as being a part of the Republic of China.
So, after overviewing the decision of the judges in this court case, would you say that the elections in Taiwan under the authority of the Republic of China Constitution are legitimate, and that such elections fully respect the democratic aspirations of all the Taiwanese people?
Let's clarify our answer by asking a rhetorical question. What if Syria sent its military troops into Jordan, announced the annexation of Jordan's territory, the mass naturalization of the Jordanian people as Syrian citizens, the extension of the Syrian constitution over Jordan, and so forth? Under such circumstances, would the United States and other leading world nations have any objections? Or would that be considered quite fitting and good? A few years later, if elections were then held in Jordanian territory under the authority of the Syrian constitution, would the election results be considered valid?
Many people have a sort of general feeling that such arrangements would not be proper, but most civilians don't have the technical legal knowledge to explain the exact details of what violations or improprieties have been committed. Fewer still can expound upon the international legal framework under which such actions must be viewed. In fact, it may be true that the Syrians can offer up all types of cultural, political, geographic, historical, etc. rationale to why Jordan should belong to them. How can we evaluate the accuracy or validity of such claims? Now, as an added complication, what if the original Syrian government collapses and flees to Jordan? What is the significance of such a set of circumstances under international law? Can we conclude that Jordan has now become Syria?
This can be quite confusing. But is it to our advantage to sort this matter out thoroughly? Or does it lack any significant reference value for a discussion of Taiwan's international legal status and the conduct of elections under the Republic of China regime?